So I just give you the outline to begin with. That seemed to be a lot simpler to me. But, as the seminar was to be is copyright, what every professor should know about copyright law. And in the advertising, I told Bud Fisher to say, well, when you're a professor, you're sort of a Jekyll and Hyde when it comes to copyright, because when you create material, you want to be paid for it, so you want copyright to be real strong, so you can get paid for it. But then in another situation, you're using other people's material, you're doing research, and then you want copyright to be weak. You want so you can use it without paying for it. So it's definitely a Jekyll and Hyde situation. So what I thought I would do, and I want to talk particularly about the TEACH Act and the new federal law involving digital classrooms, virtual classrooms, and so forth. But before I do that, I wanted just to go through some basics of copyright, and so I do this by just asking several questions, basic questions, and then answering them. I particularly spend a good deal of time on fair use, Roman numeral 7, which is very critical to education. What can be copyrighted? The federal statute, and keep in mind, copyright is all federal law. It's completely federal law. It takes, there used to be some state common law involving unpublished works and those sorts of things, but the 1976 copyright law pretty well wipes out anything with states. So we're talking about federal law here. As I noted, number 5 there, Article 1, Section 8 of the U.S. Constitution gives Congress the power to enact copyright law. In fact, the first copyright law was in fact enacted, I believe, in 1790. And in fact, it's funny that before then, a lot of people were sort of arguing at that point that Congress would have to sort of give a copyright to each individual item as it comes up. And of course, people figured out that was a little unrealistic. And finally, Congress passed a statute. And at that point, copyright lasted for 14 years, and it could be renewed for 14 more years. And I'll get to over the years, Congress has continued to expand the length of copyright. Anyway, for something to be copyrighted, the originality is the basis of copyright. In other words, for something to be copyright, it has to be original. Now, the bar is pretty low on what originality means. Okay, but there has to be something original. So, in other words, this website I created, useful websites on copyright, is probably not original enough to be copyrighted. All it is a list of links. It didn't take any creative genius to do this. It took a little work to find these sites and do a little HTML, and bingo, it's there. So it's probably not original enough to really be copyrighted. So a list of ingredients. U.S. Supreme Court 1991 ruled that a phone book was not original enough to be copyrighted. Just an alphabetical listing of addresses and phone numbers. And in that case, it was sort of tragic, because one company had spent hundreds of thousands of dollars doing this phone book, and someone else just came up and ripped it off and published their own. And the court basically said, tough luck. Copyright, it had nothing to do with sweat of the brow or how much work you do to get it. It's originality. So if it's not original, it can't be copyrighted. There's a famous quote from Oliver Wendell Holmes back in 1900 or whatever, where there was a debate before the Supreme Court over some sort of a circus poster, and the court, he just said that it's not up to judges to decide what's original and so forth. But in 1991, the court did in fact say that this phone book was not original. There was another famous case involving a photograph of Oscar Wilde, and the court, this was not the U.S. Supreme Court, but a lower federal court, the argument was, this photograph isn't original because it's just a picture of Oscar Wilde. But the court said, yes, it is, because the photographer had to decide the light, the angle, all those sorts of things did in fact make it original. Okay, so originality is not normally too much of a a big deal. Now, C there is very important. An idea can't be copyrighted, only the expression of an idea. That is critical. People don't understand that. People can steal other people's ideas, and then as long as they go and do something new, different, or they express it in a different way, it's not a violation of copyright. That's different from a patent. You know, a patent is a mechanical device, and of course you could not steal that idea that's put together. But copyright is just the expression of an idea that's copyrighted, not the idea itself. So that's people don't understand that. Now, keep in mind that what can be copyrighted is any original work in any tangible medium of expression. It has to be in other words, where someone can in fact access it somehow. It would have to be a tangible medium of expression. So in other words, it has to be fixed in a tangible medium of expression. So Lola's writing notes there. She's fixing notes right there. So that her notes there are copyrighted. They're extremely valuable, no doubt. So in other words, a completely extemporaneous speech that's never been written down, is not recorded, is not copyrightable because it's not fixed. Or somebody does a free, they do some choreography or whatever, and somebody does some dance steps and so forth. As long as they were not fixed in some way or videotaped, then it's not copyrightable because it's not fixed in any tangible medium of expression.
But you're copyrightable because he's videotaped.
Exactly. So in other words, this, of course, most of this is sort of written down anyway. So also you have a question there. You know, professors giving a lecture in a class, well, probably unless it's completely extemporaneous, it probably is fixed. Most of it's fixed because you have notes and so forth. So yeah, because this is being taped. So therefore, what I'm saying is, in fact, being fixed. What does a copyright confer? Section 106 gives the copyright owner exclusive rights to use or authorize the use of the work, subject to limitations we'll get to in a minute. These include the making of copies, preparation of derivative work. A movie is a derivative work of a book. So somebody writes a book, the movie is a derivative of the book. So the movie maker would have to get permission from the book author, the copyright holder of the book, to in fact do the movie. Okay, a CD of made from something would be a derivative work. So that's fairly self-explanatory. Distribution of copies to the public by sale or other transfer of ownership or by rental, lease, or lending, and display or a performance or display of the work publicly. Those are the basic rights that a copyright confers. How does one obtain a copyright? Once again, copyright is automatic when a work is fixed. You don't have to put a copyright notice, you don't have to register it, you don't have to do a damn thing. It's automatic. So Lola's notes are copyrighted right this very second because they're fixed. Okay, she owns a copyright in those notes. That's a common misconception. You don't have to do anything. Now, and that in 1976, the 1976 copyright law, and then some later amendments, did in fact change the United States law. We were sort of out of step with the rest of the world because we were very big on formalities, and with a copyright notice, and at least we didn't have to do a wax, like in the old days with contracts or something, with a wax seal or something. But we sort of came in compliance with the rest of the world, and the new law and later amendments basically, eliminated all the formalities. Now, that doesn't mean you shouldn't put a C, copyright 2004 by James Tidwell. That sort of puts people on notice, and it's certainly helpful, but it's not necessary.